requirement really fix this part of financial independence comes out very clearly from this document. Pensionary independence judges constitute a vital element of the independence of the judiciary. Para 25 of that. As a consequence of long years of judicial office, judges of the vetting office do not necessarily have the option to develop members from the system. The reason why the state assumes the obligation to pay pension judges is to ensure the protection of the benefits that are available after that, to ensure their ability to discharge their duties without fear of favor during the years of the judgeship. Pensions on judges, which is repealed in a way of fixed pensions. It was argued that the contingent pension scheme was violated Section 100 of the Constitution Act 1867, which provided that salaries, allowances, and pensions for judges shall be fixed provided by the Parliament. The court quoted that the judicial independence and individual or collective or institutional independence, both. The rationale for this two-pronged modern understanding of judicial independence is the recognition that the courts are not charged solely with the adjudication of individual cases. That is, of course, one role. It is also the context for a second, different and equally democratic processes to name perhaps the most important. In other words, judicial independence is essential for fair and just dispute resolution in individual cases. It is also the lifeblood of constitutionalism in democratic exercises. The court went on to review the Act of Settlement 1700, so and noted invariably financial security has been recognized as a central component for judicial independence. So I thought I should highlight these parts because very categorical findings by the Supreme Court of Canada.
When there are judgments of our court taking a particular view and by a larger bench, would we not be bound by them?
No, on this issue, I just thought as an officer of the court, before somebody else points out that
those judgments may at the most have a persuasive value. But if there are judgments of a larger bench of this court, of 3 judges bench, we are bound by that. Yes. On this if there is something against you, you must point it out. Yes, sure. Very fair on your part. Against, so since you are an amicus, there is nothing against or for.
That's right.
This issue from going from a fixed scheme to a contributory scheme came, so I just thought I should just highlight that. I just raised that observation at para 30 of the judgment, which is quoted in para 41 of my note. As I have earlier indicated, the essential condition for judicial independence at the individual level is necessity of having judges who feel totally free to render decisions in the cases that come before them. On the institutional plane, judicial independence means the preservation of the separateness and integrity of the judicial branch and the guarantee of its freedom from unwarranted intrusions by or even intervening with the legislative and executive branches. It is very difficult for me to see any connection between these essential conditions of judicial independence and the Parliament's decisions to establish a pension scheme for judges and to expect judges to make contributions towards the benefit established by the scheme. At the end of the day, all Section 29.1 of the Justice Act does pursuant to constitutional obligation imposed on the SWANSO is treat judges in accordance with standard, widely used and generally accepted pension schemes in Canada. From that factual reality, it is far too long a stretch, in my opinion, to the conclusion that 29.1 of the Justice Act violates judicial independence. I want to qualify what I have said. The power of Parliament to fix the salaries and pension of Superior Court judges is not unlimited. If there were any hint that a federal law dealing with these matters was enacted for an improper or colorable purpose, or if there was discriminatory treatment of judges vis-a-vis other citizens, then serious issues relating to judicial independence would arise and the law might be held to be ultra-virus sections. So there is no suggestion of any of these considerations.
The state's argument is otherwise.
That's all. There is no suggestion, however, of any of these considerations in the present appeal. First, the motive underlines so. Secondly, the highlighted portion. Also, Superior Court judges were required to contribute to their pension benefits commencing December 20, 1975. The contributory scheme was effectively introduced. Please mark this, minutes. Introduced as part of a remuneration package which included a 39% salary increase and 50% increase in pensions to departments. The salary and pension changes were intended to be complementary and as a comprehensive package did not diminish, reduce or impair the financial position.
So it bettered the...
That was the finding. Canada, this pension of judges, I thought we will be the only country to Canada has had 4 or 5 rounds of pension cases like ours. Very interesting. We couldn't see similar parallels in the US or any other country. But Canada, surprisingly, had.
The reason is age of retirement.
There was no. My friend says too many Indians in Canada.
No, but they're in US also. No? Yes.
Because what I read was the Canadian Supreme Court of 85, 86. Now see what the court holds in 97 plus, para 43. Subsequently, in reference to the remuneration of judges of provincial courts, the Canadian Supreme Court held that judicial salaries could be reduced, increased or frozen, but not without recourse to an independent, effective and objective commission. The court held financial security as both an individual and institutional dimension. The institutional dimension of financial security has 3 components. First, a general constitutional principle. The salaries of provincial judges can be reduced, increased or frozen either as part of an overall economic measure which affects the salaries of all or some persons who are remunerated from public funds, or as part of a measure which is directed at provincial court judges as a class. However, to avoid the possibility of or the appearance of political interference through economic manipulation, a body such as a commission must be interposed between the judiciary and other branches of government. The constitutional function of this body would be to depoliticize the process of determining changes to or freezes in judiciary. This is exactly what we are seeing from the flip-flop to hold back. The constitutional function of this body would be to depoliticize the process of determining changes to or freezes in judicial determination. The objective would be achieved by setting that body the specific task of issuing a report on the salaries and benefits of judges to the executive and the legislature. Provinces that are thus under a constitutional obligation to establish bodies which are independent, effective and objective. Any changes or freezes in judicial remuneration made without prior recourse to the body are unconstitutional. Although the recommendations of the body are non-binding, they should not be set aside lightly. If the executive or legislature chooses to depart from them, it has to justify its decision according to a standard of simple rationality, if need be, in a court of law. Across the board measures which afford substantially every person who is paid from the public purse are prima facie rational, whereas the measure directed at judges alone may require a somewhat fuller explanation. Second, under no circumstance is it permissible for the judiciary, not only collectively through the representative organization, but also as individuals, to engage in negotiations over remuneration with the executive or representations of the legislature. Any such negotiation would be fundamentally at odds with judicial independence. Because I thought I could highlight this for a reason. When a normal pay commission or an exercise is conducted with us, every other employee of the government has this bargaining power. They are all heard through their respective associations, unions, etc. This is one branch, because if I may say so, which has no access to the corridors of power. And it is that which was corrected by having a schedule commission.
But I think from what you read is that NPS report,
Yes.
the Maharashtra judicial officers were heard.
Because that's before the commission. Normally, when the government.
Before the commission.
Commission because.
Not.
The commission, because the commission considers Justice Reddy and Justice Basant, who's our colleague here now, this would be fine. But they traveled throughout the country. They had sittings in about 60 or 70 places. Interacted with all the high courts, with judicial officers from. It's not an exercise we just came just like that, sitting in New Delhi. It's already commendable work. Just like the State Commission. As I said, the Padmanabhan Commission's purview was a little smaller. It was just to index it to in accordance with the State Commission recommendation. Extensive concern seen in the introduction in the first volume of the report, and it is extracted in the judgment where this court has accepted the pay pension part, old pension part also. Extensive consultation. In India, judicial pay commissions have been constituted, which have time and again made recommendations with respect of payment of salaries, pensions, and emoluments for judges and judicial officers. The recommendation of the judicial pay commission with respect to pension should be given effect to in order to ensure meaningful realization of judicial independence. The constitutional commitment to the principle of separation of powers necessitates that the judiciary maintains a level of independence from the legislative and executive branches. Financial security for judges and judicial officers ensures independence. Security, certainty, and reliability in maintenance is an integral part of national independence. That's para 46 is the extract of the judgment in while accepting the SNJPC's report. They said, please don't look at the exercise of judicial pay pension exercise as an exercise in self-aggrandizement. It is not the judiciary asking money for itself. A financial independence has an intrinsic link to part 3. If you want our citizens to get fair justice, we need independent, impartial judges. So your lordship said in that judgment, the early judgments all permitted independence of judiciary. The 2023 judgment, your lordships linked it to part 3, saying if you want effective access to justice, you need impartial judges. If you need impartial judges, then
financial security for them.
You have to give them financial security. That is the relevant extra. I am not reading that. Need for uniformity in service conditions of the judiciary. Under the scheme of the Constitution. Under the scheme of the Constitution, India's judiciary is unified. The effective functioning of the system requires judges of caliber and capacity to be provided with the right incentives and promotion opportunities. This was
Dr. Ambedkar, one paragraph has devoted 25th November 1949. So, in that speech, he has devoted one paragraph on unitary judiciary.
I was just telling my colleague to pick it up. Para 14 of the 1993 case.
Or could be under in the 13th December 1948 speech. Either of
this 1993 judgment.
Yes.
This is rendered by my Justice Savan. It's a very interesting judgment. It makes excellent reading. One of the phrases he uses, if you render the power to the executive to completely control service conditions and payment and salaries of judges, the phrase he uses is that it will be giving them the power to twist the tail of the judiciary. That's the phrase that is employed by Justice Savan. If without any judicial consultation, without effective consultation with the High Court, and that is permissible, the phrase used by Justice Savan is permitting the executive to twist the tail of the judiciary. Secondly, the judiciary in this country is a unified institution, judicially, though not administratively. Hence, uniform designations and hierarchy with uniform service conditions are unavoidable necessary consequences. This, so far as 1993 is concerned, from those days. The further directions given, therefore, should not be looked on as an encroachment on the powers of the executive and legislature to determine the service conditions of the judiciary. They are directions to perform the long overdue obligatory duties. That's how this court classified uniformity. This was reiterated in the 2023 judgment, page 22. Equivalence of core judicial functions between judicial officers of the district judiciary and judges by. This court, in its review judgment dated 5/4/23, observed that all judges across the hierarchy of courts discharge the same essential function of adjudicating disputes impartially and independently. The court further held that increase in pay of judicial officers must be commensurate with the increase in pay of the High Court judges. The district courts and courts forming a part of the district judiciary discharge a prominent role in preserving the rule of law. Public confidence in the judicial system sustains the credibility, so and so. I am only reading the highlighted part, the underlying part. Ensuring adequate emoluments, pensions, and proper working conditions of the members of the judiciary has an important role in bearing, so and so. The legitimacy of the principle that the increase of pay of the judicial officers must be commensurate with the quantum of increase in the pay of High Court judges has been raised previously and stands judicially settled. So the inspiration I am drawing is that you can't have one half of the judiciary not drawing fixed pension and the upper half of the judiciary drawing fixed pension. That is another important distinction so far as civil servants are concerned. First distinction is a lot of our officers come in at 40, 45. So they don't have the kind of years left in service to contribute. The second is there is no other government service. You can't technically call it promotion, fellows. But on the upper echelons of the service, fellows, it is pensionable, and the lower part of it is not pensionable. Thus, from clerk all the way up to cabinet secretary,
The same.
The pension system is the same. That's not so far as judiciary is concerned. This is an important difference. The principle of equivalence in judicial function and commensurate pay was furthered in the judgment dated 19/5/23. Together, the courts constitute the unified judicial system, performing for the core and essential functioning of administrative justice. To be truly unified both in form and substance, there must be integration in terms of pay, pension, and other service conditions between district judiciary, high courts, and Supreme Court. To this end, under Article 125 and 221 of the Constitution, salaries, etc., payable to the judges of the High Court and Supreme Court are fixed by law made by Parliament. Salaries for judges of the High Court are same across the country by virtue of the High Court Justice So Act. Given that in the hierarchy of the unified judicial system, judges of the High Court is placed above a district judge, it follows that a district judge cannot have more pay than a High Court judge. Therefore, the maximum ceiling was necessary. But the underlying portion, to be truly unified both in form and in substance, there must be integration in terms of pay, pension, and other service conditions between district judiciary high courts. Plus, para 51 and 52, I have highlighted the Supreme Court judges' salaries and service of conditions act and the High Court judges' salary.
Yes.
If your lordship see part 1, clause 3, but this is mostly rendered academic now because your lordship has now held that doesn't matter from what source you come to the High Court, you are entitled to the same pay. So tomorrow in the other matters, most of the judgments, about 17, 18 matters are there. There was war motor also. Now that gets covered by that. But I only thought to show that lordships, if this system perpetuates, because what then happens is people coming.
According to you, so though the Constitution envisages a unitary judiciary, there is discrimination on one part, the High Court judges and the Supreme Court judges, and on the other part, the other judges.
And it is also an important distinction between normal civil service, where the upper ranks are the same.
So if
Same branch.
If one district judge appointed on the same day as a JMFC enters as a High Court judge, he would be treated differently. And if the second one, who unfortunately there is no vacancy at the age of 15 and a half, would not get that benefit.
See, even 30 years, both of them have put us from the age of 22, 23, nowadays.
Someone 30, someone 32.
Huh?
Someone 30 and someone 32 give us 2 years additional.
Only distinction of
Because I'm almost done. I have 2 or 3 judgments to show. I'm almost done. So that's why I thought I'll put it in the form of a written submission, because otherwise to take the.
Manoj, there are some applications also, like for example, Manoj, one application I have moved on behalf of Rajasthan Judges Association, Manoj. There's been orders of this Honorable Court, Manoj, judgments which require little direction from my lords, Manoj, because the arrears have not been paid, Manoj, to the judges. So, Manoj, these applications are listed along with. Manoj, so my lords will keep these applications separately, Manoj.
Let the main issue be decided. Don't unnecessarily get the things complicated.
item 50. This is
Yes.
in JEE admissions matter where the eligibility criteria was changed. It was listed yesterday, your lordship, it listed it today in item 50. The learned history is here. Can we have it tomorrow, your lordship, is as the first item? If possible.
But this should get over tomorrow.
After that, it's possible.
I mean, after that too.
Not too much time,
No, but we are in the midst of this matter, so we would like to first finish this.
There is some urgency only because the registration process for the examinations will start. And only if they participate in the JEE mains will they be able to participate in the JEE advance.
Do you have any instructions? Learned
I am appearing, I would be assisting the court, I am opposition there. But
Then-
it may not take long. I.
But then we are in the parted, so we will take
Thank
it.
you.
Your lordship,
After the parted, we'll take it.
is the item right after the Pandra direct?
Yes.
No. Lordship, if I may seek permission to mention item 30, this lordship involves RBI and Axis Bank. It has come up on 5 occasions, but we know lordship is busy today, tomorrow. If it can be next week or first week of February, it's already been come up 5 times.
Okay, we'll have it somewhere in February. Yes.
February first week, any date, lordship, and perhaps high on the sequence if possible, lordship.
February, except the date where we have fixed those.
If it's a fixed date, it'll be very kind of lordship.
We have fixed some Bengal water matter.
So we- Delhi.
ठीक है, फरवरी में कर दीजिए.
No, the
Any
Tel-
date?
the Telangana matters, I
Wait.
understood your lordship indicated you won't be able to take.
First, we will finish this.
No, I understand. So can there be some date, maybe Thursday, if that's possible, can it be higher?
Thursday, we are only supposed to have old criminal matters.
Friday then? Because I'm just going to press for that interim order, so just 5 minutes is all we need, even Friday if that's possible.
We'll have it
We are on the second phase of counseling,
immediately because Friday we will be,
but Monday perhaps, if that's possible. Can you?
Tuesday, I think Monday is holiday.
Oh, sorry. So you Wednesday.
Wednesday,
Wednesday,
high on board. Yes.
Wednesday. I'm good.
Lord, may I mention item 40, it's a clarification with regard to some amounts payable. Now the landlords after are back and that's listed on the 17th. So my lord, I feel today item 40 may not see.
It will not reach.
May not see the light on.
Not May, it will not.
So can I have chance? Then on
Okay,
Tuesday,
next week.
I-
Yeah. Yes.
Because I am in the connected matters in item 42. I had clarified it last time also. This 42.4 is a fresh matter. We don't even have an advance notice. So we will need instructions to below assist your lordships.
I have just one very short point.
Because not tomorrow, day after below this, all right? Because tomorrow I am not in Delhi.
Then Wednesday.
Wednesday.
Wednesday next.
Next Wednesday.
Counseling would end, yes.
Your lordship's counseling anyway has ended.
No, the third match.
Fourth January.
Still going on. Otherwise,
January below.
Thursday, we have to have only old criminal matters. That's our assignment. So Friday, we have the difficulty that we will not be available after 12:30. The bench will not be available. All first 3 courts will not be available after 12:30 on Friday.
We just know that Monday, Tuesday are holiday. Can that be on Friday then?
Friday, we are telling you that Friday is the first 3 courts would not be available after 12:30 on Friday.
Wednesday?
something could be done on Thursday.
You get the listing from the chief justice.
Milos 22nd, Milos, I have to go through some health procedure on Milos 14th. So Milos till Friday 18th, I'll be back Milos on Monday, Tuesday is a holiday. Your lordship will kindly have it on 22nd Milos, which is the Wednesday.
22nd, it will be too long,
Lordship, the day after, you know.
Day after, it's a Thursday, we are telling you Thursday we can have old criminal matters. Okay, if this finishes, we will take it.
Because I said it because tomorrow I am not there. I'm not there. Because Friday is the Lordship.
Make some alternate arrangement.
Because
Friday, we have been telling that Friday, the first 3 courts would not be available.
Because actually, because I just want, we'll make arrangement. But I want to bring it to your Lordship's notice that the third counselling has ended on 4th of January. Result has come on 4th of January. Making it with some
Just let someone be there to tell us that tomorrow that the counselling is over, we'll dispose of the matter. We are not going to ask the fresh counselling to be started. Yes, you're most welcome.
May I be going to the liberty of mentioning item 22 today, Malad? This is the 93-year-old gentleman where on 13 December you'll also be directed for listing today. It's only a very short issue, Malad, that the consent that was given for the omnibus stay pending settlement, Malad, the settlement talks will not fructify. So just that omnibus stay needs to be vacated. That's all.
We'll take it tomorrow after the part.
Very well. Much better.
If time is there. Yes, Mr. Parmeshwar.
That's out of the propositions, because I had covered already 2. That the judicial independence of the district judiciary is equally part of basic structure. Second one I had covered was at page 20. It enhances access to justice, linked to part 3. Uniformity in service conditions is page 21 to 23 minutes. Page 25 is the other objection that is often taken, that civil servants do not have parity with civil servants is sought. But that's an objection your Lordship said done away with in 1993 itself. Reiterated a number of times saying there's no question of parity with the administrative executive, but your Lordship said if at all there can be a parity, it can only be with the political executive. Your Lordship says that judges can't be equated with civil servants plus. If at best, they can be equated with the political executive, that is the ministers, etc. So that page 25, your Lordship sees para 55. That objection, this Honorable Court held that judges could not be treated from 93 onwards, could not be treated on the same footing as members of the administrative executive, and that they must instead be equated with members of the Council of Ministers and members of the legislature. It was held that parity was between the political executive, legislature, and judges. This is in the context of the first Shetty Commission recommendation itself, and the extract is there because I don't want to read that part. This was reiterated even so far as the second Judicial Pay Commission is concerned, because those 2 judgments I have mentioned at para 57 and 58 at page 26. So that objection was also been already dealt with. While at this topic, I thought I must point out that although they did away with pensions so far as civil servants and members of the service are concerned, your Lordship says interestingly, legislators in this country received fixed pension. Para 59, for example, Salaries, Allowances and Pension of Members of Parliament Act. Section 8A, kindly see 8A at the foot of page 26. With effect from 18th day of May 2009, there shall be paid a pension of 25,000 rupees per mention to every person who has served for any period as a member of provincial parliament or either house of parliament. And kindly see 8AB. So I just wanted to draw your Lordship's attention. It's not as of today we don't have a class of people who are not drawing fixed pension. 8B also may be seen at page 27. Where
for every year they increase by 2,000.
That's right, and 8.3, where any person entitled to pension under subsection 1 is also entitled to any other person. Such person shall be entitled to receive pension under subsection 1 in addition to such other pension.
So if he has retired as suppose an IS officer, so he will get that pension plus this pension.
It is not as if there are similar legislations so far as state assembly.
State legislatures are concerned. Yes.
So I have put that for Maharashtra, Uttar Pradesh, etc. para 62 at the foot of 27. The legislation governing the service conditions of the members of the legislature and indirectly the political executive incorporate the following salient features to ensure financial securities of officers entrusted with sovereign functions of the state. The pension amount payable is fixed, not market linked. Eligibility to receive pension is not contingent on any mandated term of service. Increments in pensions are assured by statute, adjusted to cost inflation. That's what I wanted to point to your lordships. 1A says it will be indexed to cost inflation. Even 1A of the Parliament Members Act, members of Parliament, it says your pension will be indexed. Kindly see page 27 for a minute, 1A. 8A, subclause 1A. The pension and additional pension to every person shall be increased after every 5 years, commencing from 1st April 2023 on the basis of cost inflation index provided under clause 5 of explanation to section 40 of the Income Tax Act. So they have assured pension. It is an additional pension which is indexed to cost inflation. The time served is irrelevant.
Even 1 year, 25,000.
Given the long settled principle of equivalence parity between judges at all ranks of the judiciary, members of the legislature and political executive, it is submitted to the aforesaid features ensuring financial security and independence are also essential for judges and judicial officers. That's 235, the law settled that the High Court has to be consulted, all the judgments are there. The Lordship sees clause 6 from para 64 to para 72 are all the judgments which says that the High Court must be consulted. I will just point out to one judgment, para 66, that is Madan Mohan Chaudhary. Para 23, which I have instructed at page 29, Madan Mohan Chaudhary's judgment. The High Court's control over the subordinate judiciary is comprehensive and extends over a variety of matters, including posting, promotion, grant of leave. The three words, namely posting, promotion, grant of leave, used in this article are only illustrative in character and do not limit the extent of control exercised by the High Courts over the officers of the subordinate commission. The Lordships have consistently said that consultation with the High Courts is necessary. So far as the switch from the old pension scheme to the new pension scheme was concerned, there was never a consultation adopted by any of the state governments with any of their respective High Court. So on that count also it must fail. Para 73 is the observation of Justice Sawant I wanted to rely on in the All India Judges case, because para 73 at the foot of page 31. In view of the separation of powers under the Constitution and the need to maintain the independence of judiciary to protect and promote democracy and the rule of law, it would have been ideal if the most dominant power of the executive and the legislature of the judiciary vis-a-vis that of determining its service conditions had been subjected to some desirable checks and balances. This is so even if ultimately the service conditions of the judiciary have to be incorporated in and declared by legislative enactments. But the mere fact that Article 309 gives power to the executive and the legislature to prescribe the service conditions of the judiciary does not mean that the judiciary should have no say in the matter. It would be against the spirit of the Constitution to deny any role to the judiciary in that behalf. For theoretically, it will not be impossible for the executive or the legislature to turn and twist the tail of the judiciary by using the said power. Such a consequence would be against one of the seminal mandates of the Constitution, namely to maintain the independence of the judiciary. So, consultation, equivalence with civil officers, all these objections have been tackled time and again. That's the other objection that was raised, is that what this in effect means it's a mandamus to release money. Because if your lordships are upholding the old pension scheme, it is in effect the mandamus for so that's the other objection they have taken in the counter affidavit, saying that your lordships will be through judicial order directing that monies must now be expended towards pension of judges, whether it is permissible or not. That's in the constitutional scheme of the United States, the US Supreme Court and some of the high courts in the United States, state Supreme Courts in the United States are involved what's called the doctrine of inherent powers. The doctrine simply stated is this, that it would be impossible, it would not be constitutionally permissible for the legislature of the executive to deny what is due, financial resources due to the judiciary, because that would in effect cripple the judicial branch itself. those judgments I have cited, this doctrine has already been approved, and those very judgments were relied on by your lordships in two judgments. One is Bridgemohan Law, page 34, your lordships have said that the concept of inherent powers that is there in the United States can be applied to us, and the question of mandamus is directly addressed. Page 34, para 79. Carroll's articulation of the doctrine of inherent powers was recognized and upheld in Bridgemohan Law versus Union of India. The lordships will recollect, Bridgemohan Law was a case where fast track courts were set up by orders of this court. After 10 years, most of the state governments said we don't have monies to carry this forward because the union scheme ran only for 10 years. Most of the judges, judicial officers came to this court saying we have given 10 years to the judiciary. If the state governments are not willing to extend our tenure, what then happens is we all go back to our earlier avatar as lawyers. The court, Millards, accepted that this inherent jurisdiction is there and it said it could issue a mandamus as well, Millards. But unfortunately, the court did not issue that direction in that case, in Bridgemohan, but it actually upheld this principle. It is thus clear that it is the constitutional duty of this court to ensure maintenance of the independence of the judiciary as well as the effectiveness of the justice delivery system in this country. I am reading the underlying portion, Millards. If the policy decision of the state is likely to prove counterproductive, increase pendency of cases, thereby limiting the right to fair and expeditious trial for litigants of this country, it will tantamount to infringement of their basic rights and constitutional protection. Thus, we have no hesitation in holding, and in these cases, the court could issue a mandamus. So, this was in the context of Millards continuing a fast track courts. In the context of pay and service conditions, Millards, by your lordship's judgment of 19th May 2023, para 80 at page 34. Your lordships have again recognized this doctrine. So that argument also is now addressed by your lordships' other bench decisions. Because all the decisions on the second judicial pay commission judges are all three-judge bench decisions. So let me just read para 25 and para 80 minutes, the extract of para 25. Therefore, to secure the true independence of the judiciary, this court has recognized that the pay of judicial officers is separate and distinct from the pay of the staff or other wings of state. This, it may be noted, is nothing but an articulation of the doctrine of inherent powers. This doctrine mandates that the judiciary must possess the inherent power to compel payment of those sums of money which are reasonable and necessary to carry out its mandated responsibilities and its powers and duties to administer justice. This doctrine is only the logical conclusion of separation of powers and ensures that the independence of judiciary is secure. Then the next objection that has been raised in the affidavits is financial burden. Lordships kindly see page 35, para 83 onwards. I have addressed that. This financial burden, page 35, para 83. Again, from 1993 onwards, this financial burden argument has been rejected in the context of judicial pay and salaries. The contention with regard to the 1993 judgment, the contention with regard to the financial burden likely to be imposed by directions in this question is equally misconceived. Firstly, the courts do from time to time hand down decisions which have financial implications, and the government is obligated to loosen its purse recurrently pursuant to such decision. Secondly, when the duties are obligatory, no grievance can be heard that they cast a financial burden. You'll also see that the financial implications are only concurrent when it comes to obligations. So, para 85 to 88 are decisions which say Millards policy decisions are not beyond the pale of judicial reviews. I will not repeat that. As the commission, Millards, one of the Lordship sees the last heading at page 37 is diversity in the judiciary. This is an English decision which the commission itself had relied on in its recommendations. Because what had happened was in England, for certain judges, they had shifted from an existing pension scheme to a new pension scheme. The transitional provision stated that certain older members of the judiciary will be retained under the old scheme, and the newer members or the younger members of the judiciary will be transferred to the new scheme. That was found to be adversely discriminatory against women and younger members of the judiciary. So this is something that the commission also has relied on, saying that if you take away financial security of judges, it has an adverse impact on the diversity quotient in the judiciary also. Because instead of relying on this, this is a judgment which the commission has relied on. May I just invite your lordship's attention to one paragraph in S.P. Gupta, Justice Bhagwati's opinion in S.P. Gupta, because I thought that is telling. Well, sorry.
Tara,
Para 27 minutes.
you can read it.
So sorry. You'll also note para 27 at 2:23 minutes. The judiciary stands between the citizen and the state as a bulwark.
One minute.
Two 223. एक पूरा वही है. 81 supplementary SCC 87. One नहीं.
You can read it, Mr. Parvendra.
Look, may I just read it? It's just easier. Sorry. The judiciary stands between the citizen and the state as a bulwark against the executive excesses and misuse or abuse of power by the executive, and therefore is absolutely essential that the judiciary must be free from executive pressure or influence, and this has been secured by the constitution makers by making elaborate provisions in the constitution to which detailed reference has been made. But it is necessary to remind ourselves that the concept of independence of judiciary is not limited only to independence from executive pressure or influence, but it is a much wider concept which takes within its sweep independence from many other pressures and prejudices. This is why I think that financial ma'am, I couldn't find a better formulation. It takes within its sweep independence from many other pressures and prejudices. It has many dimensions, namely fearlessness of other power centers, economic or political, and freedom from prejudices acquired and nourished by the class to which the judge belongs. Both ways it cuts, according to me. This one, what we are then saying is that concept of financial independence of the district judges is not only from political interference or executive interference. What you're also saying that from other pressure groups. I think that addresses the point directly. The other important part this says is, namely fearlessness or other power, or from prejudices acquired or nourished. If you want a more diversified judiciary, I think we need to pay our judges better, take care of our judges better. Otherwise, it will be the same set of or class of people who will become judges in this country. If you are to get new talent, if you are to get a more diversified judiciary in this country, the first generation lawyers have to accept judgeship. If people from rural background have to accept judgeship, become judges in the district judiciary, etc. Financial independence of judges is a necessity. So this is what I wanted to draw your attention to, saying that the way they address the concept is not just from political or executive interference, from other political pressures, other economic pressures, and also from prejudices. And that can only be tackled by diversity in the judicial market. So these are the legal propositions. Because now the three High Court judgments, swiftly, it's in volume B, First is Durve, that is the Maharashtra decision.
Everything is in volume view.
Because there are 3 or 4 volumes which contains all the footnotes which are cross referenced. Because your lordship said I don't need to take your lordship through those circulars, act, etc. Everything is there. So I have provided those volumes separately. Lordship will see the Maharashtra decision at page 52 of this volume.
So I was right. I said the author is same.
That's what I said. It's the same. Your Lordship, the issue is referred to in the first 4 lines in the quoted paragraph at page 52. Amongst various issues which are raised in this petition, at present we are dealing with 2 issues. The first issue is regarding the discontinuation of the pension scheme to judicial officers which were applicable in terms of the recommendations of the City Commission. Now a contributory pension scheme is made applicable with effect from year 2010 even to judicial officers who will have to contribute 10% of their salary into the said pension scheme. So this is the issue, Millets. Then your Lordship will see the discussions, the judgments, the resolution of the state of Maharashtra, which adopted the new pension scheme, is quoted at page 56, para 11. Your Lordship kindly sees also.
Yes.
And then below the Lordship's finding will be at page 60, para 14. Para 14. We have considered the submission. There is a fallacy in the stand taken by the state government. In fact, the state government accepted the recommendation of the Padmanabhan Committee appointed under the orders of the Apex Court. The Apex Court, by an order dated 26 July 2010, directed the benefits recommended by the Padmanabhan Committee should be applied with effect from 1st January 2006. As per the orders of the Apex Court, service conditions of judicial office of the state, including pensionary benefits, shall be in terms of recommendations of the Padmanabhan Committee, which are accepted by the Supreme Court. As far as the pensionary benefits are concerned, judicial officers are concerned, what updates is the government resolution dated 5th January 2011. Prior to acceptance of the report, the service conditions were governed by the report of Justice Shetty Commission as modified by the Apex Court. The recommendations as amended by the order of the Apex Court were in operation. Therefore, when the impugned government resolution was issued, the order of the Apex Court directing the service conditions of the judicial officer shall be governed by the Shetty Commission report was enforced. Therefore, the action of applying the impugned government resolution to the judicial officers is completely contrary to the direction of the Apex Court. In fact, the impugned government resolution is not at all applicable to judicial officers who are appointed from 1st November 2005, the terms and conditions of service. Para 15, my lords. As per the new scheme introduced by the impugned government resolution, a government servant is required to make contribution equal to 10% of his basic salary plus GNS pay. The salary payable to the judicial officers is determined firstly by payable to the by the recommendation of Shetty Commission and secondly by recommendation of Padmanabhan Committee as accepted by the APEC. The state government cannot affect the quantum of salary of judicial officers in this fashion by providing for a deduction of 10% of basic salary plus the earner's pay for the salary of judicial officer. The orders of the Apex Court do not permit such a deduction to be made. Making of such deduction from the salary of the judicial officer will be a breach of the orders of the Apex Court. Accordingly, relief was given at para 18. That is why I was saying, Milords, that the Bombay High Court puts, because it was the High Court and the Supreme Court orders then held the field, Milords, it puts it on the ground that there is a direct breach of the Supreme Court's orders because your lordships were completely seized. In other words, Milords, your lordships are the custodian of pay and service conditions of the district judiciary in this country. It's always been so post 1989. So, this gets followed, page 63 in Vijay Kumar Rai versus State of Karnataka. That's at 73, Vihar Durve is reliant. Plus page 73, Vihar Dole is relied on us and followed. Plus page 76 is the judgment of the Madras High Court.
Madras judgment. Still करना पड़ेगा.
Para 22, your lordship sees at page 86, Milods. You've seen the recommendation of the one-man commission, that is while referring to the JTC, Milods. They phrase it as a one-man commission, para 22 at page 86. We find that the recommendations are with regard to revision of pay scales and there is nothing contained in those recommendations.
Para 22 you already.
Para 22, Milods.
Yes. We have seen the
Recommendations of the one-man commission, and we find that the recommendations are with regard to revision of pay scales and there is nothing contained in those recommendations above mentioned. Patently wrong. I have just showed it to your lordships. Para 5 and para 6, your lordships will note. I've extracted the JPC's recommendation, one-man commission in my note itself. Completely erroneous reading of the so lordship, just compare it with para 5 and para 6, page 4 of my note, and this conclusion of the Madras High Court. It says there was no recommendation by the Padmanabhan Commission or Justice Padmanabhan Commission on direct recommendation directly accepted in 2000.
it says that the recommendation of the Shetty Commission would continue.
That doesn't mean that there is no recommendation. And it in any way put it on delay with us. Unfortunately, the judicial officers went a bit late to Madras High Court and then thereafter he puts it on it. It is an admitted fact that the petitioners have received the benefit of the recommendations of the commission, which was accepted by the government unconditionally, and their pay scales stood revised, and they also received the arrears in full during 2009. Even at that point in time, the petitioners did not raise even a faint plea that they should be put under CPS. They should not be put under CPS, but should be given the benefit of the old pension scheme. Therefore, the challenge to the implement orders on the ground that the recommendations of the one-man commission was accepted, they should be given the old pension scheme is an argument. It is stated to be rejected. This is essentially the finding. It's an erroneous reading of the recommendations of the commission. It's an erroneous reading of your lordship's judgment accepting the recommendations of the Justice Padmanabhan Commission. And with all due respect to the High Court, doesn't appreciate the concept of financial independence of the judiciary at all. The Madras High Court view. Plus para 24, they say it's only persuasive value. Your lordships have already seen that. Karnataka. Para 24, Milods. No, Milods, it's JPC. Your lordships are reading which para?
Was constituted to recommend pay scale for the judicial officers which recommendation was implemented by the state government, the same para 24. About 7th, 8th line from top. The recommendations do not touch upon the pensionary benefits.
Precisely for this reason, one-man commission was constituted.
So this must be Padmanabhan Commission.
Which recommendations was implemented by state government, not constituted by state government.
Okay.
That's what they did. So far as the JPC is concerned, what the states did, to all pensioners before the cut-off date in their respective states, they implemented the pay and pension for them correctly. But what they did was, they said recommendations on pensions will not be implemented for pensioners who are under the new pension scheme at all. That's how in Karnataka that was reversed, in Maharashtra it was reversed. In all those cases, the Padmanabhan Commission recommendations were holding the field. But the way the state government understood it was that this will apply only to judicial officers who are under the old pension scheme, does not apply to judicial officers who are born under the new pension scheme, in the new pension scheme. Plus the JPC, plus your lordships will note, was constituted by your lordship's order dated 28/4/2009. Just to clarify, it is not the
So
same.
merely because the court had upheld the provisions of the new pension scheme, the court finds that it will follow it.
For judicial officers. So question was not whether it is applicable for other employees or not.
It
That
was
did
with
not fall-
regard to junior assistants and
That's right. That's right.
it doesn't refer to even Karnataka.
It refers para 24 and it says it's only persuasive. We are not persuaded by it. Para 24 first 3 lines.
Para 25?
Para 24 plus first 3 lines. I'm so sorry. 26. No. That's not one. Sorry. Sorry, it's not there.
It refers only to Bombay.
You're right. So sorry.
Maybe because it was prior to Karnataka. Karnataka judgment is afterwards. Because Madras judgment is 2018. This is went there in 19. Yes.
Lordships are right. Lordships. That's right. That's while your lordships are at volume V, I just wanted to invite your lordship's attention to page 179.